governor's office and the department feels the same way. They worked very hard on this, and they were pretty proud of it when it was adopted by the state legislature. So they're heavily invested in it. Second issue I wanted just to update you on is the opinion that I issued in 2005 on the question of stock water. This was fairly controversial at the time, and is not too much less controversial in some circles today, because I had the notion that we ought to actually read the statute the way it's written. The plain meaning of the statute ought to control, but that's not the direction that it had been going. The Pollution Control Hearings Board had managed to torture the language enough to get it to cry uncle and reveal some sort of policy purpose that is not evident from a plain reading of the statute. And so when we issued this opinion, it said it means what it says, which is that there is not a limit for stock watering purposes at 5,000 gallons a day. It was fairly controversial. But you know, when I spoke to critics of that decision who criticized me for simply applying the plain meaning of the words in the statute, I said, look, if you don't like it, go to the legislature. We're not supposed to make new law by twisting the plain meaning of words and statutes to fit some new or changed policy agenda. And the state Supreme Court has been quite clear that just because you can conceive of some other interpretation of the words of the statute doesn't mean that you should do so. That the plain meaning should always come first, and that's exactly the approach we took in the opinion that we issued. As you know, that opinion was challenged directly in the Five Corners Family Farmers versus Department of Ecology and Easter Day Ranches case, where the Ecology Department was sued over Easter Day's proposal to develop a 30,000 head cattle feedlot in Franklin County. And they filed the suit in part to directly challenge the opinion that we issued in 2005 on how to interpret the stock watering provisions of the state water law. As you probably know, the Five Corners Family Farmers are a group of dryland wheat farmers with land located near the proposed feedlot in Franklin County. They were joined in the lawsuit by Scott Collin of the Center for Environmental Law and Policy and the Sierra Club. And what they were looking for was a ruling that the groundwater permit exemption for stock watering is actually limited to a maximum quantity of 5,000 gallons a day, even though it says it's actually not limited. So they wanted to stand the language on its head and reach a different conclusion. And also they were trying to block Easter Day from using more than 5,000 gallons a day for stock watering at its new feedlot operation. On the other hand, we asserted that, number one, the statute clearly does not attach any quantity limit to the stock watering exemption. Number two, that the legislature exercised its policy prerogative to provide the stock watering exemption from permitting without any gallon limitation. In other words, the legislature made this decision. So if you don't like it, go back to the legislature. And three, only the legislature and not the courts can adjust this policy by amending the statute. If you don't like it, you have to go back to where the law was made. It's extremely aggravating when people try to achieve through litigation what they were unable to achieve through legislation. But that's what this case represents, that kind of strategy. As you know, the Franklin County Superior Court issued a ruling on May 5th of this year deciding in favor of the position that we had taken, and ruling that permit-exempt withdrawals of public groundwater for stock watering purposes are not limited to any quantity. The plaintiffs, of course, have appealed. They're trying to get in front of the Supreme Court on direct review. So stay tuned. You'll be hearing more about that, I'm sure, and we will, as in the Columbia River Program case, vigorously defend the position that the state has taken, and we will be on the same side of that argument with a lot of folks in the ag sector here in Eastern Washington, but really throughout the state. So that's just a touch base. Those are some of the things we're working on. Obviously, there's a lot more going on than what I was able to cover in one speech, but again, I want to congratulate you for all that you have accomplished, for the advocacy role that the association plays, and moreover for the success that you're having as individual producers, because you have been wise stewards of the resource and have been patient enough to form this association and create an effective group advocating for sensible use of the resource to the policymakers in Olympia. It should not be taken for granted, the success that you've had, and as many challenges as you face and as much frustration as you continue to have about certain issues. I hope that once in a while you stop and smell the irrigated roses, because you've accomplished some amazing, amazing things. And I just wanted to tell you that those of us who've studied it really appreciate it. Thank you very much.
Thank you very much, Rob. Do you have a moment for questions?
Yeah, I'm all yours until 1:30.
Okay, so do we have any questions from the audience? Daryl.
Hypothetically speaking, of course, if you were governor, what do you think you would like to do at this level or at this point in time in thinking about water in Eastern Washington in terms of kinds of changes you'd like to make?
It seems to me that we want to be incenting conservation and effectively rewarding it, not putting people who have water rights at risk for conserving the water and using it wisely. So that would be one area I'd want to look at right away. And we'd probably be working together on that with the department, you, and others who actually understand why that's needed and how it needs to be written so that you don't create unintended consequences.
I guess I was just going to follow up. In your talk, you talked about problems with overreaching government in the process and stuff. And I think the stock watering case, and even to some extent the conservation O&M, difficulties that we've had, have been classic examples of that. I mean, we shouldn't even be worried about stock watering.
Right.
If there was ever an area where the state of Washington, the water master in Olympia had something better to do than worry about cows drinking water, under your opinion, and wondering whether it's water in the cow, over the cow, or under the cow, that shouldn't have happened. So that was a clear-cut case of just overreaching on the part of the agency. And the O&M, it's kind of similar in that it's like we can get all these agreements in place, except the last 5%, which are so vague. It would be so easy for the state to say, sure, let's just go do this. And we kind of got that now, and with your help, we've got some on that. And we want to move forward with it. Eventually, we would like to, see that in code. We don't want that to block us now, trying to get something done.
I agree with you, Gerald, and I know you appreciate the fact that, ecology has to interpret statutes that are made, and when they do that, they're under pressure from lots of different directions, and so they're constantly trying to satisfy lots of constituencies.
But I think just about everybody in this room, in one phase or another, in how they're dealing with government, would say our state government is overreaching in its authority right now. It needs to stop.
On the O&M issue, a lot of the O&M issue came out of the Columbia River bill in 2006. There was a huge amount of language in that bill about conservation, voluntary regional agreements that would allow ecology to work with groups like ours to craft language that would allow these types of activities. And I think one of the problems we're having right now is that bill's been in play, or it was passed 5 years ago, and yet we really haven't done a lot on the conservation side in terms of the implementation of that bill. When I say we, I mean ecology, the state, and here we are going into 2011, and we'd like to start implementing some things. The legislature passed that bill with the intent to do that, and conservation O&M is really a piece of that bill, and so we kind of feel like the legislature gave some fairly broad authority to the agency to do that, but yet we're getting caught up, like Daryl said, in the last 5%. And it just seems silly to us that a major bill like that was very much supported, and Representative Chandler was a major part of that at the time, and he'll tell you too that he feels the intent of that bill should allow for some of this stuff, and we just feel frustrated that here we are 5 years later and we're still nowhere. So
I hear you.
Yeah.
We need to do better than that. I agree.
Thank you all for coming, and I hope you enjoyed Rob's comments. So, have a good afternoon.
Nice seeing you, Derek.